Before you dive headfirst into any property deal, there's one thing you absolutely can't afford to overlook: the legal side of things. From property ownership laws to lease agreements, contracts, and compliance, understanding the legal landscape is essential to protecting your investment and avoiding costly mistakes. In this module, we'll walk you through two key areas. Lesson 1 covers the fundamentals of UK property laws every investor should know, and Lesson 2 focuses on lease agreements and contracts, what to look out for, what to include, and how to make sure your paperwork works for you, not against you. It might not be the flashiest part of investing, but getting the legal basics right can be the difference between a solid investment and a financial headache. Let's get started. Now, commercial property in the UK falls under a completely different framework compared to residential. There are no universal commercial tenancy laws. Much of what governs a commercial lease comes down to contract law, case precedent, and specific legislation. If you're buying or leasing out commercial property, you'll likely encounter legislation such as the Landlord and Tenant Act 1954, which gives business tenants the right to renew their lease under certain conditions. However, landlords and tenants can agree to contract out of this act, which essentially waives that automatic right. This is a big deal, especially if you're the landlord and want flexibility for future plans. You also need to know about planning permissions. If you're converting or repurposing a building, say, turning a warehouse into office space, you must apply to your local planning authority. The UK has use classes which define what type of business can operate in a space. Class E covers commercial, business and service uses, while B2 and B8 refer to industrial and logistics uses. Changing the class of a building without permission can lead to hefty penalties and enforcement action. Then there's health and safety compliance, such as meeting fire regulations, asbestos control, and accessibility standards. Commercial landlords are responsible for ensuring the premises are safe for occupancy. Ignoring these can open you up to legal action, or worse, endanger lives. We also have to mention business rates, essentially the commercial equivalent of council tax. These are paid by tenants or landlords, depending on your agreement, and are based on the property's rateable value. Before buying or leasing a space, always check the business rate estimates, because they can be a big part of your operational costs. Now let's move on to lease agreements and contracts, which, in commercial real estate, are far more complex and customizable than residential ones. A commercial lease isn't just a document that says you pay this much rent each month. It's a detailed contract that defines the relationship between the landlord and the tenant, everything from who pays for repairs, to how often rent can be reviewed, to whether the tenant can sublet the space. Let's break down a few critical components. First, there's the term of the lease, how long the tenant has the right to occupy the property. Commercial leases often range from 3 to 25 years, and sometimes include break clauses, giving either party the right to end the lease early under certain conditions. Next, there's rent structure. Some leases are fixed, while others include rent reviews, often every 3 to 5 years. These reviews may be based on market value, the Retail Price Index, RPI, or other formulas. Then we have repair obligations. Many commercial leases are what's called Friday leases, full repairing and insuring. This means the tenant is responsible for maintaining the entire property, including structural elements like the roof and foundation, and also covering the cost of insurance. If you're a tenant, that's a major responsibility, so always get a schedule of condition done before signing anything. Another key clause is service charges, especially in multi-unit buildings. These cover things like maintenance of shared spaces, security, landscaping, and cleaning, and landlords often pass these costs on to tenants. You'll also want to look closely at use clauses, which define how the tenant can use the space. For example, a lease might allow retail use but prohibit food service. These clauses can make or break a business, so both parties need to be clear and aligned. And finally, dispute resolution. What happens if the tenant doesn't pay rent? Or the landlord doesn't maintain the property? Good contracts include mechanisms for resolving disputes, whether through mediation, arbitration, or court proceedings. The bottom line: commercial property deals are legal minefields, and even small oversights can have big consequences. Whether you're buying, leasing, or managing a commercial property, never skip legal due diligence. Always work with a solicitor who specializes in commercial property, and don't sign anything you don't fully understand. So, to wrap up, navigating UK property law and commercial leases isn't about memorizing every regulation. It's about knowing what to look out for, asking the right questions, and protecting your investment with the right documentation. Next time, we're diving into risk management, what every investor needs to know to protect their portfolio from unexpected shocks. Because in this market, it's not just about what you gain, it's also about how well you shield yourself from loss. This has been the Eggs Invest podcast, because when you invest with insight, you invest with impact. See you next time.